I'm here to talk to you about life after the pink form. The pink form, as you know, is the homestead deduction verification form, and this was part of a piece of legislation that the General Assembly passed in 2009. Just to give you some background here, for the purpose of verifying that those individuals who were receiving a homestead deduction were eligible for it, and to try to eliminate fraud, the General Assembly set up this temporary verification program, and a form, which was supposed to be pink in color, was to be sent with tax bills in 2010, 2011, and 2012. And again, the idea was to clear up any fraud, make sure people weren't getting more homestead deductions than they were entitled to, and so forth. The way this works is that each individual who is claiming a homestead deduction, and his or her spouse, if any, is required to provide the last 5 digits of his or her Social Security number and driver's license number. And this information has been used to populate a secure homestead database used by county auditors to track homesteads statewide and prevent fraud. This was, again, a temporary program, and it wasn't really intended to punish those who were properly receiving a homestead deduction. It was simply meant to clear up fraud and make sure that those who were receiving it were eligible for it. The homestead verification form, the pink form, is supposed to be completed and returned by January 1st, 2013. And the question is, what happens on January 2nd? If a taxpayer has not returned the form to you yet, it's too early to pull the homestead deduction simply because they haven't returned the form to you. They have until January 1st, 2013 to do that. But what happens if the taxpayer doesn't return the form by that deadline, or if the form is invalidly completed? Well, I've provided here a cite to the statute 61.112.17.8, and this says that the county auditor may, in his or her discretion, terminate the deduction for assessment dates after January 15th, 2012, if the individual does not timely and validly file the form as determined by the auditor before January 1st, 2013. So notice that this is a may. The auditor is not obligated to pull the deduction. The auditor may do so. And again, I think this underscores the idea that the program was not intended to punish those who were genuinely eligible for it. The program was really intended to make sure that people who weren't supposed to get it weren't. And I think that's why there is this discretion. Now, before the county auditor terminates the deduction, he or she must mail notice of the proposed termination of the deduction to the taxpayer. So if you are going to pull the deduction because someone has not timely or validly filled out the form and returned it to you, you have to notify the taxpayer. And another very important point here is that if you terminate the deduction and the taxpayer comes back in and presents the proof to you that they were in fact eligible for the deduction, you have to reinstate it. So I just want to make sure that that's clear, that you have the discretion to pull it if someone doesn't return the form or invalidly completes the form. But if that person comes in and provides that proof to you, you have to reinstate it. Just want to make sure that that's clear. This next slide here, I think, probably reiterates what I've said here. We just tried to break it down a little bit here, make it as clear as possible. Now, this last bullet point, I'm going to emphasize this because it leads into our next slide, but even though the program is ending January 1st, 2013, this doesn't mean that auditors can no longer request information from taxpayers to ensure that they are eligible. And I think that Brian talked a bit about this in his presentation. But after January 2nd, 2013, when the pink form verification program ends, an auditor may still request information from a taxpayer to verify his or her eligibility for a homestead deduction. House Enrolled Act 1072 did introduce a couple of changes that you want to be aware of. And again, Brian talked about this earlier, but a county auditor may require an individual to provide evidence proving that his or her residence is in fact his or her principal place of residence. The county auditor may limit the evidence that the individual is required to submit to a state income tax return, a valid driver's license, or a valid voter registration card. And this could have been the result of complaints from taxpayers that they had to provide all sorts of different documents and they didn't know what they had to provide. And this lists 3 on which you can base your determination of someone's eligibility. Also, as Brian mentioned, the DLGF's corresponding administrative rule that lists all sorts of documents that a taxpayer could present is being voided by that change in 1072. And these changes take effect July 1st. So until then, that administrative rule, which is 50 IAC 24-3-2, until then, that administrative rule is still in effect, but July 1st, these changes do take effect. Now, I think we talked about this already. What happens if a taxpayer does not fully complete the verification form? Again, the taxpayer's homestead can be removed for assessment dates after January 15th, 2012. Now, does this mean that if the taxpayer doesn't want to provide the last 5 digits of his or her Social Security number, that the deduction can be removed? Yes, that's correct. The last 5 digits of the Social Security number are required for that homestead verification form. If the taxpayer refuses to provide it, that would be a basis for concluding that the form was incomplete and the deduction could be pulled, again, within the auditor's discretion. But remember, the taxpayer can come back in and provide that proof, provide you with those numbers, and if the person is eligible, then the deduction has to be reinstated. Now, here's another question that might have come up. For purposes of the verification form, if the taxpayer doesn't have a driver's license or Social Security number, the last 5 digits of a state ID number or the last 5 digits of a control number on a document issued by the federal government, such as a passport or work visa, may be provided instead. Now, these numbers are only acceptable if the individual does not have a driver's license or Social Security number and must be accompanied by an explanation of the type of number provided. So if someone tells you that they just don't want to give you the last 5 digits of their Social Security number, that's going to be a problem because they do have a Social Security number. They could provide those last 5 digits. Only if they don't have Social Security number or driver's license can these alternative ID numbers be used. Now, what if someone provides an out-of-state driver's license number? A taxpayer is not required to provide an Indiana driver's license or ID card to receive the homestead deduction. And again, this is in reference to the verification form. If the person provides an out-of-state ID, the county auditor may request additional information to be provided to prove the Indiana property is his or her primary residence. And that says, see slide 5, that should be 6. That was slide 6 is where we talked about the kinds of proof that can be presented. So you might want to consult that slide again. One note is that an individual has 60 days to obtain an Indiana driver's license after becoming an Indiana resident. So if somebody claims that they've been an Indiana resident for 6 months and they're eligible for a homestead, but they still have an out-of-state driver's license, you might want to inquire about why they don't have an Indiana license if they are, in fact, a resident of Indiana. Another question that we've received, when we remove a homestead deduction because the verification form has not been returned, should we remove all deductions except the mortgage, veterans, and geothermal deductions, since you don't have to actually reside on the property to receive those? Again, the statute that deals with the verification program only provides the authority to remove the homestead deduction if the verification form isn't returned or isn't returned fully completed. So you can't assume that, well, because we didn't get the verification form, that must mean that they don't live on the property, so we'll pull their over 65 deduction. You can't make that leap in logic. If they don't return the form or it's not correctly filled out, you have the authority, the discretion to remove only the homestead deduction. To remove other deductions, you'd have to have another basis or foundation for removing those. Now, going forward, how do we obtain information about spouses not mentioned in a deed? Well, again, the sales disclosure form requires a buyer who is applying for a homestead deduction to provide spouse information in the penalties for perjury section. See the instructions for that section. It says that spouse info, including a social security number, etc., is not necessary if the buyer is not applying for the homestead deduction. So if someone is using the sales disclosure form to apply for the homestead deduction, they have to provide spouse information, name, social security number, driver's license, and so forth. And that would be one way of determining who, I guess, who is receiving that homestead or in whose name that homestead is in place. Now, I included this slide because I thought it might be helpful. We get calls from government officials or taxpayers, and they sometimes will use the terms deduction, exemption, and credit interchangeably, but there are important distinctions. A deduction is something that reduces the assessed value being taxed. An exemption excludes property from assessment and/or taxation, and a credit reduces the tax bill. So technically, there is no such thing as a homestead exemption. It is a homestead deduction, a veteran's deduction, over 65 deduction. So it may be helpful just to distinguish those terms and make sure that you understand the differences between them. I also put in this little provision here. This presentation, other things the department will issue are not the law unto themselves. And I just want to make sure that's clear. Some folks, taxpayers, may be confused thinking that if they see a memo that we publish, that that is the law, that some state agency has stated this and so it's the law and we can rely on it as if it's the law or a legal opinion. What we provide here is simply intended to be informational. So I just want to make sure that's clear. The counties have county attorneys. If you need a legal opinion or a legal representation, the county attorney can certainly provide that assistance to you. Another kind of helpful foundational idea here, if a deduction is validly in place as of March 1st, it will stay in place for the assessment year, even if the property changes hands and the new owner is ineligible for it. And this is why it's important to distinguish between exemptions and deductions. If a deduction is validly in place on March 1st, it will stay in place for that entire tax cycle, even if the property changes hands and the new owner is technically not eligible for that deduction. An exemption, however, and I think Kathy will talk about this, an exemption will come off for that same tax cycle if a new owner is ineligible for it. So that's an important distinction between deductions and exemptions, and that's why I wanted to distinguish between those terms in the presentation. Now, another important point here, and this may be a point of confusion for some taxpayers. What if a person has a homestead on his principal place of residence on March 1st, but then moves to a new principal place of residence later in the year? There is a provision in the Homestead Deduction Statute, 1.1.1237H, and I've cited that here. If you have a principal place of residence and a homestead deduction validly in place on March 1st of a year, and you move to a new principal place of residence later in the year, you can apply for the homestead deduction for that new residence, that new property, for that same tax cycle. So it is possible that you would have two homesteads with the same person in one tax cycle, but that's only because the person is moving from one principal place of residence to a new one. For the next tax cycle, the deduction would come off that first residence and presumably stay on the new residence. So I just wanted to make that provision clear, bring that to your attention, but that is a possible scenario. All right, now these are some other kind of common questions, frequently asked questions. What happens if an individual receiving a homestead deduction transfers his property to a trust of which he is the beneficiary? Since the title of the property changed, doesn't a new homestead deduction need to be filed? We've said that if property is transferred or the title is changed, that would be a cause for refiling for the homestead deduction. Likewise, if property is refinanced, that would be cause for refiling for the mortgage deduction. Generally, deductions don't have to be reapplied for, but I've just mentioned a couple of scenarios where that would be necessary. Here, there is an exception to that rule or to that practice. And again, I've cited the statute 6.1.112.17.8e. A trust entitled to a homestead deduction for real property owned by the trust and occupied by an individual is not required to file a statement to apply for the deduction if the individual who occupies the real property receives a homestead deduction provided in a particular year, and the trust remains eligible for the deduction in the following year. Now, a verification form still has to be filed, but the point here is that if somebody transfers property to a trust and they are the beneficiary of that trust and they're residing on the property and meet all of the different criteria, the homestead deduction does not have to be reapplied for. So that the homestead deduction is basically carried over to the trust. No new application has to be filed. So again, that's one exception that you might encounter to the general principle that if property is transferred, the title changes, a homestead deduction has to be reapplied for. Now, here are some other whoppers that we get pertaining to divorce situations, and so I've tried to work through these as best I can. I've set up a couple of hypotheticals here. In the first bullet point, a husband and wife divorce after March 1st. The husband moves out, buys his own house, and applies for the homestead deduction. Should he receive the deduction on his new house, and what should happen to the deduction on the old house? Well, as we just established a few slides ago, if a deduction is validly in place on March 1st, it's going to stay in place for the whole tax cycle. So with regard to the first house where the husband and wife were living before they divorced, that deduction is going to stay on that property because it was validly in place on March 1st. When the husband moves out, the couple divorces after March 1st, he buys his own house, he can apply for a homestead deduction in his name on that new property. As we established, I think 2 slides ago, it is theoretically possible for a person to have 2 homesteads in one tax cycle if they have moved to a new principal place of residence, and this would be one of those situations. So again, the deduction would stay on the first house because it was validly in place on March 1st. The ex-husband could potentially receive the homestead deduction on the new house that he buys later in that same year. Now, what happens if the couple divorces prior to March 1st? And this is where it gets a little bit murky, but bear with me. If the wife's name was listed on the homestead application or she was a signatory to the sales disclosure form through which the homestead deduction was applied for, and she's a titled owner or is named in the mortgage, the county can probably leave the deduction in place unless the title changed following the divorce but prior to March 1st. The wife should then file for the deduction in her own name for the next tax cycle. So again, the idea here is that the county may have enough information to know that the wife is an owner of that property and that it's her principal place of residence and that she's eligible for it. Again, if her name was on the homestead deduction application or if it was in the sales disclosure form and the homestead was applied for through the sales disclosure form, and she's a titled owner or on the mortgage, the county can probably leave the homestead deduction in place for that impending tax cycle. The wife probably should then file for the deduction in her own name for the next tax cycle, just to make things clean. Presumably, if there's a divorce, the title of the property will change, and again, as we said, that would be a reason for reapplying for the homestead deduction. Now, if the wife's name was not listed on the homestead application or she is not a signatory to the sales disclosure form, but she's a titled owner or on the mortgage, then the county will have to determine whether it has sufficient information to allow or reinstate the deduction for that tax cycle. You might want to check the verification form. There are situations where a husband buys a property 20 years ago and either wasn't married at that time or maybe the homestead application at that time didn't require a spouse's information. He subsequently marries. The wife's name is put on the title. In that situation, in a sense, I mean, the wife is eligible because she's an owner of the property and she's residing there as her principal place of residence. The county is going to have to make that determination based on the facts. Now, I do put in here, regardless of whether the wife's name is on the homestead application or she was a signatory to the sales disclosure form, if she's not a titled owner or on the mortgage, then she cannot be given a homestead deduction if she divorced before March 1st. So to get a homestead, you have to be an owner of the property or you have to be buying it under contract. So if that's not the case, if she's not on the title or she's not on the mortgage, then she wouldn't qualify for a homestead deduction anyway, regardless of the divorce. And again, that's assuming they divorced before March 1st. These decisions, as I've said in this last bullet point, are ultimately local decisions. We'll sometimes get calls, what should I do? Or tell me what to do in this situation, or do you agree? Really, our agency cannot force an auditor to remove or reinstate a deduction, the auditor is going to have to make that determination based on the facts. That's something that's determined at the local level. Another situation, another question that comes up here, does an LLC have to have a homestead deduction on the property on March 1st, 2009 to continue to receive one? I don't know if there was any confusion regarding this. Our agency's reading of the statute is that no, under 6.1.11237K5, the property simply had to be eligible for the standard deduction, the homestead deduction, on March 1st, 2009. So our reading of the statute is that the LLC didn't even have to own the property on March 1st, 2009. The property simply had to be eligible for the homestead on March 1st, 2009. So just wanted to clarify that. I think that question has come up. You may have encountered that yourselves. Another FYI here, and I think Brian mentioned this in his presentation as well, another change from 1072, an amendment to the homestead deduction statute. If a property owner's property is not eligible and the auditor pulls the deduction, the auditor, when the auditor informs the taxpayer of that fact, the auditor also has to inform the taxpayer that he or she can appeal the determination to the PETA BOA. And so, that again, that is effective July 1st, and that might be something that's worthwhile to you. Someone left their glasses up here. I think that covered the information that I had. I've provided my contact information here, and the phone number there should be 9219. I swear that it was unintentional that I put the wrong phone number in the presentation. So it's 9219, and my email address is also there. Email is preferred because that way if there's a statute section or a memo or something to communicate to you, if I have your email address, if you've contacted me that way, it's easier for me to copy and paste that into the email response. So if you have a question about the presentation, or if you have some very nuanced fact pattern, I'd prefer if you could just email that to me, and I will try to get back in touch with you tomorrow, as soon as I can. So I think that's all I had, so I thank you for your time.